Number 19 CR 005, State of Ohio versus David Bailey. Mr. Bailey is appearing in custody from the jail by Zoom. His attorney is Danielle Witt, appearing from her office, and appearing from the prosecutor's office is Assistant Prosecutor King. Now, Ms. Witt, do you and your client both agree this matter can be conducted by Zoom rather than in-person appearance in the courtroom?
Yes, we do, Your Honor.
All right, and is that all right with you, Mr. Bailey?
Actually, I would like to ask, I'm going to fire Ms. Witt and to be appointed another counsel at this time.
Well, yeah, if you, the problem is you can't fire her because you didn't hire her. So, yeah, the court appointed her to represent you. My question is, are you willing to conduct this hearing by Zoom, or would you rather be present in the courtroom?
I would rather be present.
All right, we can handle that then. Let me get my assigned commissioner, and actually, Ms. Witt, are you available about an hour from now, or an hour and a half from now, or do you have other matters?
Nope, that'll be fine.
All right, we'll call the sheriff's department and have him bring him up. And probably be about an hour.
Okay.
Thank you.
Thanks.
All right. All right, are you Austin Nathaniel Bailey? I'm sorry, Hildebrand?
Yes.
Okay. All right. Case number 21 CR 020, State of Ohio versus Austin Hildebrand. This is a hearing being conducted by Zoom, a probation violation evidentiary hearing. Mr. Armentrout, William Armentrout, is the defendant's attorney. Appearing from his office, appearing from the prosecutor's office is Assistant Prosecutor King. The defendant is appearing from the jail. Mr. Armentrout, do you and your client both agree this matter can be conducted by Zoom rather than in-person appearance? All right, and are you all right with that, Mr. Hildebrand?
Yes, sir.
All right, thank you. All right, the defendant was convicted of failure to comply with the order or signal of a police officer on, let's see if we can find it here, on April the 7th, 2021. There was a notification of alleged violations filed against Mr. Hildebrand by the Probation Department that alleges that well, here it is, that was filed on June the 5th, and it alleges, Mr. Hildebrand, that you have violated Rule 2 and that you failed to report to the Probation Department since September of 2022, September 15 to be exact. Rule 3, that you failed to provide a valid updated address as directed. Rule 15, you failed to pay court-imposed financial sanctions as ordered by the court. $323.50 balance remains on court costs. It says fines, but it's actually court costs. And then Rule 19 is that you failed to comply or provide documentation of compliance with counseling center outpatient aftercare. It was signed by Officer Balser, who's also present, I believe, from the Probation Department. The court notified Mr. Hildebrand of those alleged violations, appointed Mr. Armentrout to represent him, and then set the matter for hearing today. Now, Mr. Armentrout, have you had an opportunity to review the allegations with your client?
We met and went over each of the allegations. He's prepared to admit to each one of them.
All right. Now, Mr. Hildebrand, your offense is a third-degree felony which carries a possible prison term of between 9 and 36 months. In increments provided by law, it goes from 9 to 12 and then every 6 months up to 36 months. There's also available fine of $10,000. In the event that you admit to these violations, then the court can do one of three things. I can continue community control under the same conditions that I previously ordered. I could continue with additional conditions that I think are appropriate, including extending the term of community control up to 5 years. The third and most serious is I could revoke your community control and sentence you to prison for anywhere between 9 and 36 months in the increments provided by law. You do have a right to have a hearing on this matter, and that's what we set the hearing for today, in which the state would have to present evidence through witnesses that proves to the court that you have failed to comply. You have a right to have your attorney cross-examine those witnesses to try to bring out evidence that helps your side of the case. You have a right to present testimony on your own behalf if you wish. Now, you understand the possible consequences if you admit to the violations. And has anyone promised you anything or threatened you in any way to get you to admit to these alleged violations?
No, Your Honor, they have not.
All right. Do you have any questions about the allegations or the procedure or your rights?
No, Your Honor, I do not.
All right. Then do you admit the violations as alleged in the notification filed on June the 5th?
Yes, Your Honor, I do.
All right. Anything from the state or the probation department regarding this disposition?
Thank you, Your Honor. The state and the probation department would request that the defendant's community control be revoked and that he be sentenced to a term of incarceration. I would note that this is the defendant's second community control violation since being placed under supervision. As part of his previous violation, he was ordered to complete STAR. He did so, however, after getting out of STAR, he failed to complete aftercare. He's also failed to comply with one of the basic requirements of supervision, which is reporting. He just admitted that he hasn't reported since September of last year. So, based on that, it is the position of the state and probation department that this defendant is not amenable to community control. That's all, Your Honor. Thank you.
Mr. Armstrong?
Your Honor, speaking with Austin, and it doesn't take much to figure it out. The reason he's failed to do or not done what he was supposed to do, but he relapsed again. He's hoping that the court will consider sending him back to the STAR relapse program.
Mr. Hildebrand, anything you'd like to say?
Actually, yes, there is. First off, I just want to apologize for my actions. I do accept full responsibility for that. I did relapse on the drugs that I was using, and they took me way out there, and I couldn't control myself. And I just wanted to apologize for that and accept full responsibility for my actions. If the court would give me a chance, I do have a plan of action set in place in my head and with family members as well. At first, my most successful thing when I first got out was STAR. STAR helped out a lot. I went to TCC after that. I was doing great, and I feel like that was my best option. I feel like that still is my best option because they helped me to understand completely why I had this disease in my body, and I just hope that they would take that into consideration and give me a chance. That's all you're.
All right. Well, your plan doesn't give me much confidence because up to date you've had your own plans and you made your own decisions and you've done a pretty lousy job of it. That's why you're where you're at. And I understand the state's position, and you know, ultimately that's probably correct, but I'm going to do this. I'm going to give you one more chance. I'm going to mark that down here. Because you relapsed, you didn't commit any new crime, but not reporting is significant. I mean, that's been several months. But I'm looking at your record. You don't have any previous felony conviction. So it's the order of the court your community control be extended under the following conditions. First, you're to successfully complete the STAR relapse program and aftercare. Secondly, I'm going to refer you to the drug court for evaluation and discussion with the coordinator to determine whether you would like to apply it for that docket. Your term of 3 years would normally have been up in June of next year, but because of your absconding, the time you were gone told, which means it doesn't count, and I believe that was issued on January the 6th. So for since January the 6th, that hasn't counted at all. So that's 6 more months. So that'll extend your term an extra year and a half beyond the original. And the reason I'm doing that is to give us time to make sure that once you get through the STAR program, if you do, that you get into treatment and that you're going to remain in treatment and transitional housing and hope for sober living. Drug court is not something I order you to do. You have to apply for it. But I think your only chance is to be in that program. But that's up to you. If you don't want to apply it, that's fine. But regardless of which way it goes, this is your last chance. All right. You have any questions?
No, I do not. Thank you, John.
All right. Thank you. All right. Stevie Colder. All right, are you Stevie Colder there at the jail?
Yes, sir.
All right, if you would keep your voice up there and sit close to the microphone, Ms. Coulter. This is case number 22 CR 130, State of Ohio versus Stevie Don Colder. This is a final pretrial. Actually, it's a hearing, I believe, on intervention in lieu, I believe. Let me look here. Okay. All right, Ms. Coulter is appearing from the jail. Her attorney is Dennis Kirk, appearing from his office, and appearing from the prosecutor's office is Assistant Prosecutor King. Now, I have here a proposed plea of guilty, an intervention in lieu of conviction, but I don't see a motion for that. I don't have any information that the last hearing we had was on June the 7th, was an evaluation on her mental status. Can counsel...
So, Mr. Kirk filed that motion back on September 16th, 22.
Oh, all right.
And then on September 23rd, there was an entry referring her to probation to be assessed.
Well, I don't think that ever happened.
I don't either.
Unless Mr. Kirk, do you know if your client's had an evaluation?
I think the probation department's on the line here, and Ms. Sturgill might be able to speak to that because I did refer information over to her.
Yes, sir, we have met with her and we have done an assessment for residential treatment. She does meet the criteria and she's been accepted at the counseling center. I am waiting on a confirmation bed date letter, but it should be, if I have an officer that can take her down, we can take her down.
Well, I don't have a report from the probation department. Mr. Arjima would have to file a report, and he's not done that, correct? No. Well, I'll just say yes, if it is correct, because if he's done it, I don't have it. That's why I'm asking. Mr. Arjima's not on the call. Yeah. Well, I mean, it sounds like she's going to be eligible, but we need to have a report in order to do that. So, if you would, Mr. Sturgill, get a hold of Mr. Arjima and get him to get that report to us as quickly as possible. We'll try to set this next week. What's the proposed bed date for her?
It's very flexible. I can do it within, if you set the date, I can have it arranged for the day after.
All right.
You said as soon as tomorrow.
Pardon me?
I thought she said as soon as tomorrow that date would be available, Your Honor. I didn't-
Yeah, it probably is, but the problem is we don't have the paperwork that we need because, the motion was filed and then back then you were having issues and we had to, and that wasn't done because of all the other things that happened. And so we're going to need to put this off till next week. Let me get the assignment commissioner here. We'll get a date, and then I will give you a target date for a bed, Ms. Sturgill, assuming that she meets the criteria. Is Mr. Arjima working today?
Yes, sir.
Okay. Do we have any time Wednesday?
June 28th?
Yeah.
We have plenty of time.
Okay. All right. I have most of the day available.
There's people that are on vacation.
Mr. Kirk,
Your Honor, which day are you talking about?
28th of June.
Looks like I'm in juvenile court on a half day in the morning. I would have around probably 2 to 2:30, 3 o'clock, that range in the afternoon available.
All right, let's do 2:30 Wednesday. Do it by Zoom. This will be Ms. Coulter's hearing, and then Mr. Arjima's got to get us send him an email, tell him what it's going to be, and tell him we need that report.
What do you need?
Yeah, it's an intervention in lieu. Yeah,
The assessment?
right. Yeah, we did not order one because of the other proceedings.
Okay.
Now, the other thing is, Mr. King, we'll have to notify the victim as well. Well, I see, did the victim, yeah, we do have a request form in the file, I see. So, was the victim aware of today's hearing?
Yes, sir, Your Honor.
All right, well, if you'll notify them that this is just continued in progress then.
Yes, sir.
Okay, so it'll be continued in progress to that date.
Okay.
All right, so hopefully we'll have a bed for you next Thursday, Miss Coulter, or shortly thereafter as possible. Okay.
Okay, so possibly if he gets the paperwork back, could it be as soon as tomorrow?
No, I can't do it tomorrow, and I don't think you can get the paperwork to us. So we're going to have the hearing next Wednesday at 2:30, and I think that and he has to have a little bit of time, a couple of days to get that paperwork ready.
Okay.
All right, thank you. All right. All right, are you Seth Ryan Beatty, appearing from the jail?
Yes, sir.
Okay, this is case number 23 CR 90, State of Ohio versus Seth Ryan Beatty. This is a pre-trial being conducted by Zoom. Mr. Beatty was indicted on 2 counts of pandering and obscenity involving a minor, both second-degree felonies. His attorney is William Armentrout, appearing by Zoom from his office. Appearing from the prosecutor's office, Assistant Prosecutor King. This is the first pre-trial, final pre-trial set for July 5. We have a trial by jury set for the 24th of July. I see that the state did provide the discovery and has also requested discovery. And did you file your bill of particulars, Mr. Oh, yes, I do see that. Okay. I forgot to ask. Now, is this a case involving local victims, or is this one of those internet victim cases?
Local, Your Honor, and the legal custodian has been notified.
All right. So they were informed of the time, place, and purpose of this hearing and the opportunity to be heard.
Yes, sir, Your Honor.
All right. Thank you. All right. Now, the defense discovery then will be due by the final pretrial, Mr. Armentrout. And do you anticipate any pretrial motions?
Not at this time, Your Honor.
And has there been a written plea offer provided?
There has been, my client was made aware of it.
Okay. Are there any other matters that need to be discussed then at this time?
No, Your Honor.
No, Your Honor.
All right. We'll see you then on the 5th, Mr. Beatty. Thank you.
All right, thank you, Your Honor.
All right. Dustin Schwalbach. Timothy Williams, because JD is on the call. We'll go ahead and get that one in now. So we won't have to wait till 2. All right, are you Dustin Schwalbach at the jail?
Yes, Your Honor.
All right, it's case number 23 CR 91, State of Ohio versus Dustin Jack Schwalbach. Mr. Schwalbach's attorney is William Armentrout. This is hearing being conducted by Zoom. Defense appearing from the jail. Mr. Armentrout's appearing from his office, appearing on behalf of the state. Assistant Prosecutor King. Defendant was indicted for having a weapon under disability, a third-degree felony, and a forfeiture specification. This is a first pretrial, and final pretrial is set for July 5th, and the trial date is July 27th. I see the state provided discovery. And was there a bill of particulars requested? Yes, the bill of particulars has been filed. All right. All right. Now, defense discovery will be due by final pretrial. And Mr. Armentrout, do you anticipate any pretrial motions?
No.
All right. If there are any, they'll be due by final pretrial. Has there been a written plea offer provided?
There has been, my client was made aware of it.
Okay. Are there any other matters to discuss at this time?
No, Your Honor.
All right, we'll see you on the 5th then, Mr. Schwalbach. Thank you. Timothy Williams is next up, and then after him we'll need Jamie Weiscutt. All right, are you Timothy James Williams, Jr.?
Yes, Your Honor.
Okay, this is case number 23 CR 95, State of Ohio versus Timothy James Williams, Jr. It's a pre-trial being conducted by Zoom. Mr. Williams' attorney is Catherine Hatner, appearing from her office. Appearing from the prosecutor's office is Assistant Prosecutor King. This is the first pretrial. Defendant's final pretrial is set for July 19, and his trial date is August 7th. I see the state has provided discovery, and I believe the bill particulars as well. Yes. All right. And you received those, Ms. Habner?
I have, yes.
All right. Your discovery will be due by the final pretrial. And are you anticipating any pretrial motions?
Not at this time.
All right. Well, if you do have any, they'll be due by the final pretrial. Has been a written plea offer provided yet, Ms. Habner?
Yes, I did get that earlier this week, but I've not yet had a chance to be out to jail to talk with Timothy about it.
Okay. Are there any other matters then that need to be discussed at this time?
Not this time.
All right. Thank you. All right. And the next one, Mr. Wagner will be doing Mr. Weisskopf's bail review. All right, are you Jamie A. Weisskopf appearing there from the jail?
Yes, sir.
All right, this is case number 23 CR 115, State of Ohio versus Jamie A. Weisskopf. This is a bail review hearing being conducted pursuant to Criminal Rule 46 by Zoom. Mr. Weisskopf's attorney is Jacob Wagner, appearing from his office, and appearing from the prosecutor's office, Assistant Prosecutor King. Defendant was indicted along with two co-defendants in a joint indictment. He's charged with, in counts 9 and 10. Count 9 is aggravated trafficking of methamphetamine. Count 10 is aggravated possession of methamphetamine, both are third-degree felonies. All right, Mr. Wagner, you would like to address the issue of bond?
Yeah, excuse me, sir. I've gone out to see Mr. Weisskopf, Your Honor. He represents me based on my file. I don't know that he has a prior felony record. Again, don't quote me on that, just speaking with my client. In addition, Your Honor, he indicates he is in a relationship with a significant other who I believe is pregnant at this time. He says he has ties to the community, represented. He had some employment maybe in the Wilmington area. We would just ask the court for any type of modification whatsoever.
Mr. King, on behalf of the state.
Thank you, Your Honor. The state would ask that the current bond remain in place. From just a very quick check prior to the start of this hearing, I did not see any prior felony convictions, but I would note that it appears the defendant had an abduction charge bound over in Clinton County last month. However, I don't believe he's been indicted yet on that case.
According to the court network, it shows it's kidnapping. Is alleged kidnapping is what the warrant was entered into originally. Now, what it's been bound over by, I don't know. So, Mr. Wagner, are you aware of what the situation is with that case?
I am not, but I would advise respectfully, Your Honor, my client not to say anything. He is being recorded.
Yeah, right. All right. All right, well, for the time being, the bond will remain the same, since he has a charge in Wilmington as well as here. It'll be subject to review if you have any further information, Mr. Wagner. All right.
Yes, sir.
Thank you. All right, I believe that completes the Zoom docket, and those of you who have clients Stephen C. Weil. Case number 23CR110. And Mr. Wile's appearing on the screen marked Stephen Weil. Mr. Wile's attorney is Jacob Wagner, who's appearing by Zoom. Also appearing is Assistant Prosecutor King. Did we have James Earl Jones on the docket today?
I think so.
Well, I don't have his file. I don't see him here.
Thought I had him here. When was that printed?
I don't know. Doesn't say.
I'll go look.
All right. If it is, I need his file.
Okay.
Do you know what that Jones case was about, Mr. Wagner?
Pre-trial.
What's a pretrial? All right, he's in custody?
He's in custody, sir, yes.
All right. We're going to see where that is. All right, we're getting back to Mr. Weil. This is a first pretrial. The defendant is charged with 3 counts of aggravated trafficking of methamphetamine, 1 in the vicinity of a school, and 2 counts of aggravated possession of methamphetamine, as well as a forfeiture specification. This is a first pretrial. Final pretrial is July 19, August 10 is the trial date. See, the state has provided discovery, and you've received that, Mr. Wagner?
I have, sir.
All right. And your discovery will be due by the final pretrial. Do you anticipate any pretrial motions?
Not from my first reading of the discovery, Your Honor.
All right. Well, if there are any, they'll be due by final pretrial. Do you have a written plea offer yet?
I do, sir.
Is your client aware of it?
I believe he is, Your Honor.
All right. Any other matters need to be discussed then at this time?
Nope, he's out doing well.
All right. And we'll see you on your final pretrial on the 19th, Mr. Weil. Thank you.
Yes, sir.
All right. Let's see. Stand by, Mr. Wagner. We're going to... All right, are you James E. Jones appearing there from the jail?
Yes, sir.
It's case number 22CR186, State of Ohio versus James E. Jones. This is a pretrial being conducted by Zoom. Mr. Jones is appearing from the jail by Zoom. His attorney is Jacob Wagner, appearing by Zoom on his behalf, and appearing on behalf of the state from his office is Assistant Prosecutor King. Defendant's been indicted on aggravated trafficking of methamphetamine and aggravated possession of methamphetamine, both second-degree felonies, and possession of cocaine, a fifth-degree felony. This is a first pretrial. Final pretrial is July 19, and trial date is August 17. I see that the state has provided discovery, and you've received that, Mr. Wagner?
I have, sir.
All right, your discovery will be due by the final pretrial. Do you anticipate any pretrial motions?
No, I don't, Your Honor. Maybe my client does, but
Well,
at this point, I don't see one. Maybe a Fourth Amendment issue.
all right, well, your attorney will talk with you about that, Mr. Jones. They'll be due by the final pretrial.
Sorry.
Is there a written plea offer provided?
Yes, and relayed.
All right, defendant's aware of it, all right. Are there any other matters that need to be discussed then at this time?
No, sir.
All right, then we'll see you in your final pretrial, Mr. Jones, thank you.
Yes, sir. Thank you.
All right, Mr. King, if you could come on over, I think we have Mr. A. Cannon. Present for the state, Assistant Prosecutor King. Present on behalf of the defendants, Attorney William Armentrout. And you are Brandon A. Cannon.
Yes, sir.
All right, Mr. Cannon is charged with theft, a fifth-degree felony. And this matter was set for hearing on question of intervention in lieu plea. And I do have the pre-sentence report, which indicates at the time the assessment had not been completed. But then I see here there is an email from Soda Pink Valley dated 6/21. Says they'll fax over diagnostic assessment and treatment plan upon completion. Has anyone received that?
Yes, I received one from Deputy Strain just earlier.
From who?
May I approach, Your Honor?
Yeah, 6/21?
Yes.
That's what I have. It says that they saw him, but they don't have a assessment and treatment plan yet. Have we received anything from the Soda Pink Valley Mental Health on Mr. Cannon's?
That's what Eric sent.
That's the only thing we have?
That's all we've gotten, yeah.
Okay. All right. So apparently they haven't prepared the report yet,
Okay.
unless you have it with you.
No, sir.
Okay.
When I went there yesterday, they said that she said she's waiting for her supervisors to sign it. That was.
Well, apparently they didn't.
Judge, if you remember, the reason for going there yesterday, he had it previously scheduled, and they had the evaluator had to reschedule.
Yeah, I understand.
Okay.
Yeah, and we had thought maybe it would be
Done,
but it's not. So, well, should have had her wait. She's getting her exercise here today.
Yes.
better just stay real close. Okay, we need to get a new date on this.
I was gonna tell you, you reached your buzzing limit.
I've reached my limit?
Buzzing limit.
Well, I'll raise my limit.
I know. Didn't know.
Yeah, okay. Yeah, that's a good thing is I can raise the limit.
I do.
Yeah. Let's look next week, Thursday. Well, see, Thursday and Friday we have trial.
Yeah, you can. That Wednesday that we set the Coulter.
All right, let's go. Would you be available next Wednesday, Mr. Armstrong?
1:30 or 2?
Judge, I don't have my calendar on my phone. I know I am in the morning, Judge, I'm not sure about.
You're available in the morning?
What time?
I say you are available in the morning?
We could do 9.
Um,
9, we have a 10.
We have a 10, so how about,
That's a Zoom.
yeah, that's a Zoom, so how about 11 o'clock? All right. So we'll continue this in progress to 11 o'clock. And once we get that report, Mr. Cannon, assuming that they, did she indicate to you that she was going to recommend treatment?
Yes.
Okay, because you do have to be in a treatment program accepted, so, okay, so as long as, once she gets that paperwork, we'll go ahead and move it forward.
Was that gonna be on Zoom, sir?
Pardon me?
Does that be on Zoom or would that be in person?
We can do it by Zoom if that's easier for you.
I mean, I go to the probation office for my Zoom, so
Okay. You don't do it from home?
I haven't figured it out yet, sir.
Okay, well, I understand. It took us months to do that. We'll go ahead and do it in person.
Okay.
All right.
He'll give you assignment notes here, you can step on up.
Okay.
Intervention in this.
Yeah, just continued progress so that we can get the official report. Yeah. Yeah, next Wednesday, 28th. Mr. Cannon, you get an assignment notice there from Bailey. All right, David Bailey. Oh, wait a minute, Miss Witt's not here yet. See, who is Casey? Is Casey Lundy here?
Yes, Your Honor.
And all right, case number 22 CR 55, State of Ohio versus Casey Kyle Lundy. Present for the state is Assistant Prosecutor King. Present on behalf of the defendant is Attorney Jacob Wagner. Are you Casey Kyle Lundy?
Yes, Your Honor.
Okay. All right, Mr. Lundy was convicted on June 1st, 2022 on a charge of breaking and entering, a 53 felony. There was an allegation filed on May 24th by Officer Kelly of the Probation Department, who was present, alleging that Mr. Lundy had violated Rule 1, Rule 2, and Rule 7. The matter was set for hearing today. And Mr. King has the, I know this case predated Marcy's Law, or at least, but the amendments, recent statutory amendments to the statute, not the constitutional provision, but has that victim requested notification of these matters?
The victim has been notified, Your Honor, and has indicated they would not be present.
Okay, because I don't have a VRR form in the file, but
I don't have one either.
all right. So they have been
But they're aware of this hearing,
of
yes.
the purpose, place, the time of the hearing, the right to be heard.
Yes, sir, Your Honor.
All right. All right. Now, Mr. Lundy was advised of the alleged violations, and the matter was set for hearing today. Court appointed Mr. Wagner to represent him. Mr. Wagner, have you had an opportunity to consult with your client regarding these matters?
We have, sir. We make an admission, waive a hearing on those matters.
I'm sorry?
We have discussed the allegations. We waive a hearing and would admit to the
Okay.
violations.
All right. Well, Mr. Lundy, just to put in the record, on May the 24th of this year, Officer Kelly from the Probation Department filed a notification that you were given a few days ago that alleges that you violated the conditions in the entry that was filed June 1st, 2022, as follows. Rule 1, that you were found guilty of criminal damaging in Lebanon Municipal Court on 1/29/23. Rule 2, you failed to report to your supervising officer on 12/28/22, 3/9/23, 5/9/23, 5/17/23. Rule 7, that on or about 4/26/23, you consumed methamphetamine and amphetamine. So those are the allegations. You recall those allegations?
Yes, Your Honor.
Okay. Now, you have a right to have a hearing on this matter, and that's what we're here for today, in which the state would be required to present evidence that proves that you have committed this violation, or these violations. You have a right to have your attorney cross-examine the witnesses the state presents. You have a right to present evidence on your own behalf, if you wish. You're not required to. Now, in the event that it's found that you violated these conditions, whether that be by a hearing or by your own admission, one of three things can happen. The court can continue your community control under the same conditions previously ordered. I can continue it with additional conditions that I think are appropriate, including extending it to up to 5 years total from the original 3-year period. And the third, the most serious, is I can revoke your community control and sentence you to prison for a period of between 6 and 12 months and fine you $2,500. Do you understand that?
Yes, Your Honor.
Do you understand the allegations?
Yes, Your Honor.
Has anyone promised you anything or threatened you in any way to get you to admit to these violations here today?
No, sir.
All right. You have any questions at all about the procedure?
No.
All right. Then do you admit the violations that were filed against you on May 24th?
Yes, Your Honor.
All right. Anything from the state or the probation department regarding disposition?
Thank you, Your Honor. Given that this is the defendant's first community control violation, the state and the probation department would ask that he be continued on community control in order to complete the STAR program. I believe there's very real concern of an ongoing methamphetamine issue here. He had a positive screen on April 26th, failed to report to probation twice in May. And I know I don't appear for notifications, but it's my understanding that the defendant initially failed to appear at the notification on June 14th and then appeared the next day. I feel this defendant needs the structure that STAR would have would offer him. So that's all, Your Honor.
Has he been evaluated for bed, for STAR?
Your Honor, no, but I do keep in contact with STAR program, and they advise that their bed wage usually 2 weeks at the most.
About 2 weeks?
In 2 weeks, yes.
Okay. Mr. Wagner?
Yes, sir, go ahead and stand up, Casey. You're right. I don't 100% disagree with some of Mr. King's statements that there needs to be maybe a tightening, or shall I say, restricting of the noose a little bit on this case for Casey. I don't know that it rises, in my opinion, to the level of STAR assessment. I don't know that my opinion really matters. I think it's yours. But Casey, from my understanding, Your Honor, is under supervision for felony in Warren County. It's my understanding he's in that drug court program as well. He did present me today here. I did show his probation officer a drug test from the Talbert house where he's negative on all panels. When I saw him on the sidewalk here today, I was going to ask if he wanted to roll the dice and test for the court and see where we're at. But again, before I even asked him, he presented me with the clean drug screen from the Talbot.
What date was that?
Today. Today is 6/22 at 10:58, I believe, Your Honor.
When did he go into drug court in Warren County?
That was the circumstances of being.
Said when did you get into drug court on the drug court docket in Warren County?
It was the same time I got that charge. That was.
Well, I don't know when that is. Can you tell me?
It's been about 6 months.
About 6 months.
I'm sorry, Your Honor. I got in a bad car wreck in my memories. I mean.
When were you in a bad car wreck?
The last September. And I'm still going to the doctor on a regular basis. I mean, I had a severe, what's it called, brain surgery. And,
Trauma?
yeah. That was on September 15th.
So you're going to Talbot House?
Yes, Your Honor.
And in Lebanon?
No, Wilmington, and I've been compliant with them. I'm pretty sure they've sent her.
So why haven't you been reporting here? If you've been in the drug court program over there for 6 months, I know we have a drug court here. One of the things we tell people is you got to comply with every place that you're on probation. And it may be a pain and may be more work, but just doing the drug court docket's not enough. So why didn't you report?
Anytime that I didn't, I called and talked to her.
No, but that's not up to you, is it? You know,
They
tell you when to report. You know, it's not, you know, the defendants get to choose when, where, and how they report. They're told to report, and they do it. And if they don't do it, then they're here. And that's why you're here. So, do you have any good excuse?
No, I don't have
Okay,
any
I didn't think so. Why don't you just say that? You know? So, now, getting to that point, and I don't want to hear any excuses, is that, you know, you're going to have to report if you're going to stay on community control in this court. And, you know, I appreciate the fact you're in drug court, and I hope that's successful. Although, you know, it doesn't sound, I mean, you picked up this criminal damaging charge after you were in drug court, didn't you?
No, that's the date that I went into drug court.
Oh, so they sent you to drug court after you got that conviction?
Yeah, they offered.
What are you in paper for, and what case are you in drug court for?
I voluntarily got into drug court.
What is the charge that you are in drug court for? What were you convicted of that put you in drug court?
May I ask him, Your Honor?
Well, I just asked him. I mean, I don't know. Can you ask it in a better way?
Maybe, so this is a misdemeanor that we admitted to. Did you have an original felony charge?
No.
Is that in the municipal court drug court or the common pleas drug court?
Common pleas drug court.
All right, so you have to have a felony conviction to be in the common pleas drug court, I believe.
Your Honor, if I may, Officer Kelly's indicated she believes it was a possession of methamphetamine charge.
All right, and when was that?
Not sure about that, Your Honor.
So when did you get convicted of possession of meth in Warren County?
I've never been convicted. I got convicted for theft there.
Felony?
Yeah, and that was the same time.
Okay, that's where, okay, see, I'm trying to find out if you could just give me the information. I would think if I were on probation for a felony and facing a possible prison term, I would sure know what that charge was.
I do.
Okay, if you do, then just tell me, what is the charge you're on probation for, or community control for in the drug court in Warren County?
Sorry.
Theft?
Yes, sir.
Felony?
Yes, sir.
All right. All right, then, anything else from council?
Nothing from the state, Your Honor.
Nothing, sir.
Well, since you're in the drug court in Warren County, I'm not going to put you in the STAR program. I'm going to continue. It's ordered that your community control be continued under the additional conditions. First, you're to successfully complete your Talbot House treatment. Secondly, you're to comply with the Warren County Drug Court conditions. Third, community control is extended by 1 year. Fourth, you're going to serve 10 days in the county jail, and you're going to go back to jail with the sheriff there today to serve that. And this is what's called, I guess my dad would have called an attitude adjustment, in that, you know, your attitude isn't very good. And you're real lucky I didn't send you to prison. The only thing that keeps you out of prison is the fact that you're in drug court. But I'm beginning to wonder how successful that's going to be, because I deal with people in drug court all the time, and I've had people who have been in drug court for 6 months, and they're a lot sharper. They got a lot better understanding what's going on about the program than you're able to communicate. Now, maybe that's just because that's you, and you have some issues. But, you know, you're gonna need to understand that, when I tell you to do something, I expect it to be done, and I don't expect you to be coming in here and, not being able to give answers and, not being able to talk about things. You need to start paying attention, not just to me, but to any judge that's got you on community control, or any judge you're appearing in front of. You better start listening, paying attention. So, when you get out of jail, you report to probation department. 10 days would be, let's see, today is June the 21st, so that would be, okay, you're gonna get out on Sunday the 1st, so you report on Monday the 3rd to officer. Are you gonna be in the office that day?
Yes, Your Honor.
All right. Report to Miss Kelly on Monday. Give him a time after court. All right. Anything further?
There you go.
All right. You're remanded to custody. All right, this is case, we're on Dan.
Yes, Your Honor.
All right, this is case number 19 CR 005, State of Ohio versus David E. Bailey. Appearing on behalf of the State of Ohio is Assistant Prosecutor Attorney King. Appearing on behalf of the defendants, Attorney Danielle Witt. You are David E. Bailey?
Correct, sir.
Right, and Mr. Balser is appearing on behalf of the Probation Department. Mr. Bailey was put on community control originally on March 21st of 2019 for aggravated possession of methamphetamine, 5th degree felony. There have been 2 additional entries that had been added, June the 4th of 19 and February the 16th of 22. Now, there was a notification filed on June the 7th by Officer Balser alleging that Mr. Bailey violated Rule 2, that he failed to report since May 12th of 2023. Rule 7, that on or about 6/6/23, he admitted he consumed methamphetamine and ice within the last 48 hours. On 4/14/23, tested positive for methamphetamine. Rule 15, failed to pay imposed financial sanctions. In the supplemental entry filed February 16th, he was to complete residential treatment and aftercare, and it indicated he has failed to comply or provide documentation of compliance with Soda Pink Valley aftercare. Now, those were filed and signed by Officer Balser on June the 7th and filed with the court. Mr. Bailey was informed of the allegations, and the matter was, and Ms. Witt was appointed to represent him, and the matter was set for an evidentiary hearing today. All right, now, Ms. Witt, you've had an opportunity to review the notification with Mr. Bailey.
Yes, Your Honor.
All right. Does he wish to have a hearing on this matter?
I do not believe so, but if I may go through it rule by rule with the court.
Sure.
He does admit to not complying with rule number 2, however, will admit that he did not report 1 week to probation before he was arrested. He will admit to the 2 violations under rule number 7. Regarding rule number 15, I would like the court to know that a payment was made on June 9th with payment arrangements being made on May 8th. So 1 payment has been made. And will admit to the not providing documentation of the aftercare.
All right, so which time is he admitting he failed to report?
I don't have a calendar in front of me.
It says he hasn't reported since May 12th.
He's saying it was 2 weeks after that. He did not report. The week after Mr. Balzer returned from vacation.
I could provide some clarification here, Your Honor. The defendant came to probation on June 6th, and Officer Balzer arrested him at that time because he had a warrant.
Oh, okay, so he reported and got arrested?
Yes, sir, Your Honor.
Okay. Okay. So you're saying he didn't report from May 12th until June 6th? All right, is that in dispute?
No, Your Honor.
All right, you admit that, all right. Mr. Bailey, you have a right to have a hearing on these allegations in which the state would have to present testimony and evidence to prove to the court that you've committed these violations. You have a right to have your attorney cross-examine the witnesses that the state presents. You have the right to present evidence on your own behalf if you wish to do so, but you're not required to do so. Now, in the event it's found that you have failed to comply with these conditions, I can do one of three things. I can continue your community control under the same conditions that I previously ordered. I can continue it with additional conditions that I think are appropriate. Or the third, and the most serious, is I can revoke your community control and sentence you to prison for a period of 12 months and fine you $2,500. Now, do you understand the allegations against you?
Yes, Your Honor.
And you understand your rights?
Yes.
And you understand the consequences of admitting to these violations?
Yes, Your Honor. May I have a moment with my attorney?
Sure. All right. Has anyone promised you anything or threatened you in any way to get you to admit to these violations, Mr. Bailey?
No, Your Honor.
All right. Then are you admitting to the allegations that were filed, as we've discussed here, on June the 7th?
Yes, Your Honor.
All right. Anything from the State Probation Department regarding disposition?
Thank you, Your Honor. The state and the probation department are requesting that the defendant's community control be revoked and that he be sentenced to a term of incarceration. I would note that this is his third violation since being placed on community control. The probation department and Officer Balzer have gone above and beyond attempting to help this defendant. He's been to the Massey House. He's been to the Rulon Center. He's been to Star. He's been given chance after chance, and here we are. He continues not to comply, and he continues to use methamphetamine. I don't think this defendant is amenable to community control and would request that it be revoked, Your Honor. That's all. Thank you.
All right, Ms. Wick.
Yes, Your Honor. We asked the court for Mr. Bailey to be in mental health counseling. He's addressed to me that he significantly needs that, and I believe from what he has told me, he has about 170 days of jail time credit. I have not verified that, and has also completed STAR, so he feels that mental health counseling would be the most useful to him at this point.
Mr. Bailey, anything you'd like to say?
Yeah, Your Honor. Oh, sorry, Your Honor. Although it doesn't say on this paper, I was in fact aftercare from March 12th, and it does say group, individual. So I just wanted to let you know, I just did, when I said I blew it off, I did go there to do it. And I was there until I was arrested.
And where was that?
Or the group or where I was arrested.
Where were you getting treatment?
Side of the Paint, Middle Valley, here in Hillsborough.
But you didn't provide any proof of that.
I was told that Miss Sherry emailed Mr. Balzer because Mr. Balzer had gave me an ultimatum to get into treatment or he was going to violate me then. That was been over a month.
My question was, you didn't provide any proof of that, did you?
No, Your Honor.
All right. So, and even though Mr. Balzer told you he needed it, right?
Yes, Your Honor.
Okay. All right. Now, are you on probation out of Warren County for something?
Yes, drug charges, sir.
And when was that?
Easter of 2 years ago or last year. I ain't really for sure. I think it was the last 2 years ago.
And I know that there was a report that, well, that was actually back in 2022. I know you left treatment there. So what treatment were you required to complete in Warren County?
It was called Genesis. It was a faith-based program. They were trying to push their views on me, and that's why I left there.
Okay. All right. Anything else?
I really would, I know I don't deserve a chance, but I really do want this chance because I know I messed up here, but I have failed with continuing this aftercare and the mental health that I need because I was in a psychiatric hospital for 8 days. The medication that they can prescribe me, I feel I can beat this.
Where were you in the hospital?
It was in Columbus. It was the Ohio Psychiatric Hospital.
And so are you taking medication?
Currently, I've been out of it for a while, and I've been trying to get to see my psychiatrist to give me more pills, but he's booked up and from their county, so it's kind of like a pig in a poke, trying to get to him.
Dan. Mr. Bailey, you know, this court and probation department has worked with you and worked with you and worked with you. You know, you've been in here, this is the third time. You've also been in Warren County, and I know at least, you know, you didn't comply with their program. You say you've been doing the things, but you never provided them any proof. And I would think that, you know, it would have been easy if you'd just gotten the information from Soda Paint Valley to provide to them. You're still using drugs. Everything about you is that somebody else is supposed to have done something for you, and they didn't. You know, you couldn't get your pills refilled because you couldn't get a hold of a doctor. Well, I can't imagine that, you know, you couldn't have made an appointment in a reasonable period of time before that they ran out to do that. But it appears to me that, you know, you're just not going to comply. You're going to just do whatever you want to do and expect everyone else to deal with it. And so I'm going to deal with it. It's order of the court that your community control be revoked, that you've proven that you're not amenable to community control, and it's the order of the court you be sentenced to the Correctional Reception Center at Orion, Ohio for a period of 11 months. According to the sheriff, in the 1, 2, 3, 4, 5 different times you've been incarcerated, including this current time, it's 167 days. That was as of June the 19th. Today is the 22nd, so that's 3 more days. So you're given credit for 170 days. Now, upon completion of this sentence, it is possible that the Adult Parole Authority will put you under post-release control for a period of up to 2 years. They don't have to, but they can. If they do, you'll be supervised under the conditions they set by a parole officer. If during that period of time they fail to, or you fail to comply with those conditions, they can return you to prison to make you serve additional period of up to half of your prison term for 1 or more violations. But if you're convicted of a new felony while under post-release control, then in addition, whatever sentence a judge in a new case can impose upon you, the judge is also authorized to sentence you for committing that offense while under post-release control, in this case, to an additional period of a year, whatever time's left on that period of post-release control, whichever is greater. You're also ordered to pay the court costs, which judge has granted execution's ordered, and if you fail to do that, the court clerk can collect that through various means, including levy on bank accounts, wages, earnings or other assets you may have. If that doesn't collect it, upon completion of your prison term, not while you're in prison, but once you get out, you'll be permitted to do community service, which must be done in this county, and you'll be given credit for each hour you work in an hourly rate set by the court. Each hour you work, reduce your judgment by that amount until paid in full. All right, is there anything further from counsel?
Just one thing, Your Honor, regarding the jail time credit, the defendant also spent 133 days at STAR.
Oh. Okay. Well, 11 months would be 330 days. All right, and then what I'm going to do is this. I'm going to vacate the prison term, and I'm going to find you're in violation. I'm going to order you to be to serve. Let's see, that'd be 330 days. So 303 days credit gives you 27 days from today. All right, so the court then will find that he's violated his community control. Okay, I'm going to vacate then the revocation in the prison term because of that. There's no sense. We wouldn't get him up there for probably a week anyway. So, defendant's found violation. He's ordered to serve 27 days in the jail. Pay court cost. And community control is terminated unsuccessfully on the 27th day. Let's see, 27 days from today. Today is the 21st, so we have 9 days in June, 18 days in July, so it'll community control terminated unsuccessfully July 18th. You'll be off the paper. In this court, you'll have to report to Warren County when you get out of jail. And you're still ordered to pay the court cost, and the same thing applies. If you don't pay them, clerk can collect that, put you in collections, and if not, court can order you to do community service. All right, anything further, counsel?
No, Your Honor.
All right, thank you.
Please rise.